Нет, я просто зашла, случайно накликнула на закрепленное и смотрю, что я закрепляла.
Януся, мікрофон.
Ой. Я перепрошую.
Hello, everybody. It's good night there. It's barely afternoon here. Oh, okay. All right. So got 29 students online. We ended up after 3 or 4 weeks to try to do this. I finally got 13 students who supplied some kind of a attempt to do a case brief. So, and then some of those did the Newhoff case and didn't do the next assignment to do either Mate or Weiner. So we'll have to sort that out somehow. I can't grade a paper that I didn't receive. So, but let's go on and we're gonna go ahead and work through these 2 cases, Mate and Weiner. There actually a lot you can learn from these cases in addition to what is intended to be the main point of them. You were on last week. Remember, we talked a lot about employment law in general, which of course the Weiner case leads into, and we should have done that in the other order, talked about Weiner and then talked about employment law, but we're doing it backwards because to try to get some more of these case briefs in. And from reading the ones that I received, I'm more convinced than ever that it's a good exercise for y'all to use that framework to try to analyze these cases. And I think it will help you to try to understand these cases that are not that obvious even to Native American speaking law students. So and so we're going to look at some of the case briefs that were turned in and discuss them and talk about how they could be improved to hone your legal analysis so that when you go in front of a judge, you'll be, really sharp and be able to bring out the issues, bring out the key facts that will win your case. Because that's how you win, by drawing the judge's attention to what you think are the most important things that support your position. I have to say, some of the case briefs talking about the key facts kind of gave a long kind of narrative summary of the facts, which is okay. But what you really want to do, and what this exercise is meant to get you to do, is really focus in on what is the most important thing, and leave some of the other details out, and really focus attention on where you want it, which is important in a contract case or any other case you might be arguing in court. So let's start with the one that is not the employment law case. Matei versus Hopper. We're going to just discuss it a little bit, and then we're going to go through some of these case briefs that were turned in and read them and kind of analyze them and where they're good or how they can be improved. We talked before about trying to do a clinical class like that, working with the students, and when we started off with 94 students, that was too many. And now we got 29 online and 13 that are actually handed in assignments. So that's getting to manageable thing where we can discuss each assignment that was turned in and try to learn something from it, from what was good about it or what could be improved. Before we look at the case briefs that were turned in, who can try to do a case brief for this case? So first of all, with and we're talking about Matei versus Hopper. That's the what's the scenario? What's going on in this case? How did the dispute arise?
The plaintiff was planning to construct a shopping center on a tract adjacent to defendant's land, and he attempted to force defendant to sell his property, and he offered several and after several attempts and proposal, the parties signed a deposit receipt, and under its terms, the plaintiff was required to deposit $1,000 and was given 120 days to examine the title and consummate the purchase. And in this contract was a condition that the purchase would be made only after obtaining satisfactory leases.
Okay, so it's a real estate developer. Y'all understand what that is? So this is like European, all the condo buildings everywhere. So some real estate developer came in. There was a little dacha in the countryside, used to be the countryside in European. Somebody comes in and says, I want to take that little country farmland and turn it into a condo tower. And I want to have shops on the ground floor. I want to have an Italian restaurant and a wine shop and, a nail salon and a yoga studio. And so that's what the developer is thinking about doing. And he's trying to buy the land from the lady and one thing which is, I don't know if I put it in the key facts, but it's important that they had negotiated several times before. I think it was the third try to reach a deal where he offered her one price and she said no. And he offered another price and she said no. He offered a third price. If you're somebody selling a piece of land to a developer to build one of those condo towers, what's the most important thing to you? What is the most important term of a contract of anything you're selling?
The price.
The price. That's right. What are the three most important things? The price, and the price. The price. That's the most important thing. The developer offered one price. He said no. He offered another price. No, I don't want to sell. He offers another price. She goes, yeah, for that price I will sell. When you're selling something, the price is the most important term. And I think that's important to the court in this case. But anyway, that's the fact scenario. He thinks he has a deal. He's offered a price. She says yes. Did they write out they get a lawyer to write out a long purchase and sale agreement? It's 10 pages long with a lot of legal clauses and stuff in it.
They signed a deposit receipt.
Yeah, so that's important. So, and again, y'all are taking this contracts class, and you're going, teacher, where are the contracts? We're studying all these cases. There's not a contract in any of the cases. In one case, they open a box and find some papers. In another case, the auntie says, I'd like to give my $80,000. All these cases where legal obligations are arising or not arising without any contract. Nobody went to a lawyer's office. And again, that's something to always keep in mind as an attorney or just in your life that, the question always arises, even if you're not sitting in the office with a lawyer writing a long contract with all these clauses, is an enforceable obligation being created? Is somebody making a promise that can be enforced? Sophie, they open the box, Sophie makes the promise, oh, I won't claim my part of your land if you don't bother us on our land. It's a promise. She gets taken to court. Is it enforceable? That ends up being not an enforceable contract. So this is another case. There's no contract. Nobody sat down in a lawyer's office and wrote out a contract. You have a real estate developer, doesn't have his lawyer with him, have the lady selling the land. She didn't have a lawyer. So they're signing this form that the developers use. That's a deposit receipt that basically says that he's documenting that he's given her $1,000 before they actually execute the contract. Do you think that's important?
Yes,
Why would that be important?
because it was like deposit.
Yeah, well, it's a deposit. Well, one, it's showing good faith, and the whole case eventually is going to turn on his, duty of good faith. But it's also, he's given something. If you hand somebody $1,000, is that consideration?
Yes.
Yeah.
Yes.
Well, it is and it isn't. So in this case, is that the whole purchase price? Is he going to buy her land for $1,000? Does it say in the case what the actual purchase price was? It's $57,000 or something. Anyway, he's not paying the whole purchase price. He's not giving all the consideration, but it's got a partial consideration showing that he's serious, and he's given her something. He's out $1,000. It doesn't say when the lady says, no, I'm not going to sell my land, does she give him back the $1,000?
No.
Yeah, I'm not sure it says in the case, but so she's going to back out of the deal and keep the $1,000. Is that does that seem fair?
No.
No, not really. So the court doesn't really talk about that, but that's probably important to the court. And I think that's an important point to make. As lawyers, you're getting the judge to decide on the law, but there are always factors in these cases that make one party more sympathetic and one party less sympathetic. They're factors that may not be the deciding legal issue in the case, but it makes it seem unfair to the judge, or one thing is fairer than the other. And I think that the court doesn't really talk about that either. The court doesn't make an issue out of, well, the guy's already given up $1,000 and this lady has his $1,000, but probably in the back of the judge's mind, that's an issue. Okay, so I'm just going through these. So going through these sections of the case brief. So what would you say is the issue in this case?
Was the contract enforceable and lacking in mutuality?
Okay, now that's true in the most general sense. Remember, I told y'all that when you're talking about the issue of the case, you need to take that kind of general rule and fit it to the facts of the case. How would you change that rule, that's correct, but how would you fit some facts of the case in to make the issue more specific? And think like you're talking to the judge. You come into a courtroom, judge bangs his gavel, goes, "Counsel, what's this case about?" And you're going to say, was the promise illusory? And what's the judge going to say? What promise are you talking about? And why would it be illusory? So what would you answer to the judge to help the judge understand what the case is about? Tell them, is the promise illusory? The judge is like, what promise? Tell the judge in one sentence what the case is about. Judge, this is what you have to decide. Somebody take a stab at it. He's going to be the next famous lawyer from Ukraine.
Was a deposit receipt an enforceable promise?
Yeah, and that's getting more specific. And so it raises a couple of questions. Like, one, there's not a written contract in this case, is there? There's not some 10-page contract that the parties sign. There's a deposit receipt. And you have the most important terms. When you're selling a piece of property, like I said, what are the most important terms? Like, I'm the seller. How much are you going to pay me? That's the most important term to me. How much are you going to pay? And the second term is like, when are you going to pay it? Are those terms of the contract addressed by the deposit receipt? And I think the answer is yes. So they've agreed on how much to pay, when to pay. He's made a partial payment. And so what's the issue? They have a price. They agreed on the price. What's the issue? Why is there an argument? Well, one reason there's an argument isn't there is because before the time for all these things to happen, there's 120 days supposed to happen. The developer's supposed to be able to do certain things in those 120 days. One thing would be to come up with the rest of the money, right? He has 120 days to come up with the rest of the money. He's got 120 days to check the title. So if he gets to check the title, would that invalidate the contract? There's no mutuality, no consideration. You understand what I mean by the title? When somebody's selling a piece of property, you do a title search. That really, what that does is you search the court property deed records. What's the first requirement for this lady to sell this property? What has to be true? Think of the most fundamental thing that must be true before this lady can sell this piece of property. What is it? It's so obvious y'all can't think. Y'all looking for something hard. It's easy. Before she can sell the property, she has to own the property, right? Can she sell the property if she doesn't own it?
No.
No. So a title search, that's a legal search done before property is sold. And it makes sure that this person selling the property actually owns the property. You say, that's stage of the professor, that sounds crazy. But you'd be surprised how many cases there are of people that ended up in court, people trying to sell something that did not belong to them in the first place. So with that explanation in mind, does giving the real estate developer, giving the buyer 120 days to check the title, does that possibly invalidate the deal? He's got 120 days, he gets to check the title, and if the title's no good, he doesn't have to buy the property. Does that invalidate the deal?
Yes.
Why? Well, let me give you another. The first, and I appreciate you're working. You're doing great, trying to grasp this. But actually, the answer is no. Why would the answer be no? Given the buyer 120 days to check the title, nobody ever considers that might mean there's no consideration, no mutuality. And why is that? Why is this question not raised because he gets 120 days to check the title? Well, one, think what the title search is for. If she doesn't own it, she can't sell it. So giving him time to check the legal records to make sure she really owns the property, that's not invalidating the deal. That's proving she can keep her side of the bargain. You know, another thing you find in these title searches is, okay, maybe she owns the property, but she was in a car wreck and somebody sued her and she owes them money and they put a lien on that property, L-I-E-N, a lien. That means somebody has made a legal claim to that property because she owes them some money. Or maybe when she bought the property, she owns the property, but she bought it with a bank loan and she hasn't paid the bank back. And so there's a mortgage on the property. If I buy your property, do I want to take the property with a lien against the property that somebody can come and force the sale of the property to collect on their mortgage or to collect on their lien? Do I?
No.
No, I don't want to buy that piece of property. So nobody's concerned at all that the buyer is going to get 120 days to check the title, because either one, if the title's no good, that lady can't sell it. She has no right to sell it. So he's not, there's nobody has any problem letting the buyer check to make sure the seller can really sell the property. Obviously he doesn't want to pay her. What happens if he pays her and finds out she doesn't own the property? What has he acquired? If she doesn't own the property, but she says she does, and he pays her, what does he get? The property? No, he gets nothing. If she doesn't own the property and he pays her, she might run off to Mexico with his money. He hasn't acquired anything. And he go down to the court and say, but I paid this lady $100,000 for this piece of property. And the court will say, I'm sorry, she didn't own it. Your $100,000, you might as well have set it on fire. You just lost your money. Sorry, too bad. So there's no issue. There's no problem with saying, give the guy a chance to make sure that she really owns the property. And also it's considered fair, they don't even discuss it, that he's really getting what he thinks he's getting. So if he thinks he's getting $100,000 piece of property, he's not getting a $100,000 piece of property that has a $50,000 mortgage on it and a $50,000 lien that somebody placed an attachment on her property because she owed them money from a car wreck. So, he's making sure that he's not going to acquire this property and any debts that go with the property. He wants the property, right? He don't want the property and her debt on the property, right? He don't want her debt. He wants to build a condo tower with a wine shop. It's like y'all have an Airbnb. He doesn't want her debt. You don't want to pay to get her debt. So 120 days to let him check the title and make sure she really owns the property and that there's no debt attached to the property. No problem. What's the problem? Where does the problem come from?
They talked about satisfactory releases.
Yes, that becomes the issue. Now, of course, I think this is important to the court too. Did the developer say, I don't want to buy the property because I'm not satisfied with the leases? So you understand, and the developer, he's talking about something in the future. Like right now, it's just somebody's farm out there in Irpin or Bucha, and he's buying it, and he's going to build that condo tower. And before he builds the condo tower, he wants to make sure he has tenants to go in the bottom floor, have the restaurant paying him rent, the nail salon paying him rent, the wine shop paying him rent. And so he wants to make sure all that's in order. Does that benefit the lady or him? This condition that lets him make sure he's satisfied. And you understand, Coldwell Banker, that's a whole third party. Coldwell Banker is a realty company. So he's buying the property from the lady, and he's hired a real estate company to get tenants for this building that doesn't exist yet. And he wants the real estate agency to line him up a restaurant and a nail salon and a wine shop and a yoga studio to go in the bottom of this condo building, like you see all over European. So does that clause benefit the real estate developer who wants to buy the property or the lady selling the property?
Real estate developer.
Yes, it benefits him, and that's important to understand. This because it's a weird thing about this case and how it turns out. But anyway, but that's the issue, right? Getting back to the question, the first question, what is the issue? The issue is whether that clause that allows him to gives him 120 days to be satisfied with the tenants, with the leases, for the people who are going to lease the bottom floor of his condo building. That's the issue that's argued in court. Is that the real problem? Did the deal fall through because the leases were not satisfactory?
No.
Did the developer complain about the leases? Why did the deal first fall through? What was the first sign of a problem with this deal? Real estate developer wants to buy the land from the lady. They think they have a deal. Sign the deposit receipt. He gives her $1,000. What's the first notice anybody has that this deal that looks like it's going to happen, everybody's agreed on the main terms, and then all of a sudden it's not happening? Why?
No,
Because the real estate developer said, I'm not satisfied with the leases. Why is it?
Sell the property.
Yeah, so this is something, and gets into a concept that we'll study more when we get into, especially the sale of goods. It's called an anticipatory repudiation. They have 120 days to finish this deal, and during that time, she says, forget it, I'm not selling the land. Do you think that she decided not to sell the land because she was concerned about the leases in his condo building?
No,
What do you think? Why do you think she decided not to sell the land?
maybe it wasn't her land.
Well, that might be one reason. And I've had deals fall through. People negotiate, very hard to negotiate with. It turns out they didn't have what they were claiming they could deliver. That happens in real life. And be careful, don't assume that people can deliver what they say they're going to deliver. Because sometimes they don't have it and they're not going to get it. But I don't know, it doesn't really say in the court opinion, but if I were going to guess, it probably, the lady had turned down 2 offers as not enough money. And then she probably figured out how much money this developer was going to make when he built this condo tower and leased out all the apartments to students at the state tax university, and then got all these paying tenants on the ground floor, got a restaurant paying him rent and a wine shop paying him rent. And you'd probably go like, I didn't get enough money. He didn't pay me enough. I'm just guessing, but I bet that's why she said, I'm not selling the land. I don't think she cared one thing about his satisfaction with his leases. Her reason was like, I should have gotten more money. Or maybe she decided, I don't ever want to sell the land. The land is where my grandfather was born, and I don't ever want to sell the land for any amount of money. Anyway, but it was the amount of money that she didn't want to part with her land. And her reason had nothing to do with the leases. But this happens a lot in court cases. Her real reason for not selling the land was not what ended up being argued in court, because she doesn't really have a case, does she? If she just goes into court and says, I changed my mind, I didn't get enough money, what's a judge going to say? Too bad, you already made a deal and you're in a contract. So this thing about that's her way to try to weasel out of the contract. She decided, whatever reason, she changed her mind. So it's an important thing to recognize in these cases. It'd be a whole different case and probably a whole different decision if and that's why we do this section on the key facts. Like, you change one fact and say, this deal didn't fall through because the lady changed her mind and said, before the developer had a chance to pay her the rest of the money, which he was willing to do, right? She came and said, I'm not going through with this deal. She didn't wait for the time, to give him his whole time to get the money together. So it's a different case, right? If at the end of the 120 days, he comes and said, haven't quite been able to come up with all of the money. I'm, $50,000 short. It's a different case, right? Totally different case. Or what if the deal falls through because the developer says, I'm not satisfied with my leases that Caldwell Banker Real Estate Company got me. I wanted to have a fancy French restaurant, and they only got me an Italian restaurant. How can I do this deal and have the condo development with an Italian restaurant? I wanted the finest French restaurant. Is it a different case?
Yes.
Entirely different case, yeah. So, anyway, the real issue is the lady, she decides she's not going through with the deal. We don't know exactly why, but she decides she's not going through with the deal. That's the real problem. But the issue that's argued in court, she's trying to get out of the deal and say, my promise was not enforceable. And remember, this is what all these cases are about. People walking around, and this is a problem after you go to law school, that you'll walk around the rest of your life, everything you say, you go, am I making an enforceable promise? If I say something, is somebody going to be able to hold me in court to this? And the whole thing is, she's decided for some reason she don't want to sell that land. And so how can she get out of it? If there's a contract, if there's a valid contract, she can't just go to court and say, I changed my mind, it wasn't enough money. The court says, I'm sorry, you signed a contract, it's enforceable. You can't just change your mind. So she's got to come up with some other reason that the promise she made to sell the land is not enforceable against her. And so that becomes the issue. It's like, well, and what is she saying? I'm backing out of it because the developer had a right to back out of it, right? You know, he could have, according to this contract, he could have said, I'm not satisfied with the leases. Now, how is that different from him? He has 120 days to decide whether he's satisfied with the leases. How is that different from him having 120 days to decide or to find out that the title's no good, that she doesn't own the property, or she, you know, somebody has a lien on the property? How are those different? I'm the developer. I say, I'm going to get back out of this deal because I'm not satisfied with the lease. I wanted a French restaurant and they only got me an Italian restaurant. Or if I'm the developer, I go in and say, you know, I searched the title and found out the lady doesn't own it. She doesn't own the property. How are those different situations? Well, in one, this is another concept we'll study in contract law. If we get deep enough into it, we're kind of making slow progress. But in one case, the deal's impossible, right? You can't hold it against the real estate developer. If he finds out she doesn't own the property, she can't sell it. So that's not any, you know, the law doesn't hold the developer accountable for that. But what about if he just says, I wanted a French restaurant and all I got was a measly Italian restaurant? That's not a case of the deal being impossible, right? The deal could still go through. Now, you know, we're holding the real estate developer accountable because he's going, I'm holding out for a French restaurant. But and if that had happened, this might be an entirely different, with the same facts, with the same agreement, with the same deposit form. And again, remember that, you know, the importance of the deposit form is there's no contract in this case. There is no written contract. Nobody sat down and had a lawyer draft out the, you know, long sales agreement with all the terms and everything. This is a deposit form. But that's held to be an enforceable agreement, legally a contract, even though it's not a formal written contract. It's held enforceable like a contract because in this case, you know, the main most important terms are agreed to, which are the price and the time to sell. If the developer had tried to back, but with those same facts, if the developer tries to back out, it's probably an entirely different court decision, right? Based on the same agreement, the same deposit form. So, so we got, you know, refined what the issue is in this case. Is that deposit agreement, which is not a formal written contract, is it still an enforceable promise, enforceable against both sides, even though it has this term in it that says he gets 120 days to decide whether he's satisfied with the leases? And again, probably an entirely different result, an entirely different party would win if he had been the one to come in and say, I'm not satisfied with the leases. But that didn't happen. He's satisfied with the leases, but the lady is saying, because he had the opportunity to back out if he were not satisfied with the leases, I'm saying this is not a mutual, and notice that there are different terms used that all mean basically the same thing. And this can be confusing, especially for y'all, since you're not, your first language is not English in most cases. All these terms that are used that mean basically the same thing. Remember, they talk about, Tatiana mentioned one of them, mutuality. Also, they use this term illusory. And then they also use our favorite word that all these cases have been about, which is what?
Consideration.
Consideration. Don't forget about consideration. So you got consideration, you got mutuality. Is it illusory? They all really mean the same thing or have the same effect. It's like, is this promise enforceable as a contract? And the question is there a lack of mutuality? Because he had a right to back out of the contract, but he did not back out of the contract. She tried to say, I can back out of the contract because you could have backed out of the contract, even though he did not back out of the contract. So I think, part of what the court is doing there, and it's important to understand as a lawyer, is like, yeah, that's true. Did he have a right to back out? Yeah. But did he try to back out? No. Had they agreed on the most important terms, the price and the time? Yes. So I think the court understands she's really trying to back out of the contract for some other reason that she does not want to abide by the contract. And we don't really know what that is. But with that, see how we refined what the issue is in this case, beyond just, is it an illusory promise? Is the promise illusory under these specific set of facts? That's the way you need to think as a lawyer. Okay. What are the positions of the parties?
Defendant claimed that the deposit receipt was no more than offer by her, which could only be accepted by plaintiff, notifying her that all of the desired leases had been obtained and were satisfactory to him. Also,
okay, well, let's stop there. That's good. That's enough to talk about right now. So, so basically, and when you're talking to the judge, the briefer you can be, the better. These students, I'll give you the long answer. The best answer is the briefest answer you can give. And her position is, and Tatiana said it along with the other things, is that she's saying that the deposit form was just an offer. And so understand we're talking about another very important contract concept. This case is supposed to be about consideration, right? Was there consideration to make the contract valid? But what's really going on here is also a related issue of contract formation. It's another legal principle of like, what do you have to do to form a contract and have it be valid and enforceable? And so she's not really talking about the issue of consideration as much as she's talking about, has the contract been fully formed yet? And in the process of negotiation, people go back and forth making promises. And so, and we'll look at some cases that deal with this issue specifically, but in this kind of theology of contract law, the two important concepts are offer and acceptance. To form a contract, somebody has to make an offer and somebody has to accept the offer. When an offer is made and accepted, we saw some of these crazy cases that were also, they said they were about consideration, but it was also really about offer and acceptance. Remember, the guy said, if I hear from you by 4 o'clock today, I'll sell you all this cotton. And the guy writes back by 4 o'clock. And the guy says, no, you know, you've followed the terms of my offer, but I've changed I'm not selling it to you. And in that case, back in England in the 1800s, they said that was okay because there was no consideration at the time. This, the guy said he would sell the cotton if he heard back by 4 o'clock. At that time, there was no consideration for that promise. And of course, that concept had to change, because if that were the case, how could we do modern commerce? That decision was basically saying there's no consideration until you've paid your money. Now we do deals all the time where I make a promise, you agree to the promise, I agree to you agree to the promise, and we say we have a deal. Nobody's paid any money yet, no goods have transferred yet, no cotton's been sold. So we've rejected this idea that you can say, I'll sell you this cotton if I hear back by 4 o'clock. And I answer by 4 o'clock, and he says, no, and I don't have to sell it to you, because even though you did what I asked, there was no consideration. We've gotten rid of that or gone past that, because there's no way modern commerce could function between the United States and Ukraine or anything like that. You know, the money can't be handed over at the same time the contract is made. And this case, Mattei versus Hopper, is just a, you know, minor example of that. That agreements are made, the money's paid later, the property's transferred later. It, you know, can't all happen at the same time. But so anyway, the issue is not really one of consideration, but of contract formation. Has a binding contract been formed already, even though the consideration has not been exchanged? You know, in the early days, you saw in that case, promising the consideration was not enough. You had to already give them the consideration before you had a contract. Obviously, modern commerce cannot work like that, and that's been abandoned. So in this case, you know, the promise has been made, and is the promise good? So so anyway, she says the issue is not consideration. We're really just in the process of contract formation. And when you gave me that deposit agreement, that was your offer. Or actually, I guess she said it was the reverse, that she was offering to sell at a certain price. And how could he accept? What was her position? What did he have to do to accept her offer?
Notify her that all desired leases had been obtained.
Yeah. So she said, because you had this condition that you had 120 days to be satisfied with the leases, that until you inform me you're satisfied with the leases, we have no deal. There's no contract. And that's really what she's saying. She's not saying there's no consideration for the contract. She's saying no contract has been formed yet. You know, they had agreed on the consideration that he was going to pay her a certain amount of money. But she says the contract is not formed yet. I've just made you an offer to sell the land and you can accept it. Of course, what do you think is one reason the court probably did not accept that argument? What's the problem with her saying, I offered to sell at a certain price and you can only accept it by notifying me that you're satisfied with the leases?
In contract wasn't mentioned that notifying is necessary.
Yeah, that's what the court says. But what's the other? I think there's a more obvious reason. And sometimes, like I said, it doesn't hurt you as a lawyer to outthink the court. But in reality, did she make an offer at a certain price? Did she go to him and said, I'll sell you this land for this price?
No, the plaintiff did it.
Yeah. She did not, in reality, she did not make the offer. The real estate developer made the offer. He said, I'll pay you this much money for your land. So his version is, I offered this amount of money and you accepted it. And you allowed me 120 days to come up with the money, be satisfied with the title search, and to be satisfied with the leases. You know, and the reason the leases are a problem because it seems to give him this unlimited ability to back out of the deal, where he can just say, I'm not satisfied with the restaurant that Caldwell Banker lined up. I'm not satisfied with the wine shop. You know, I want it to sell Argentine wine, and they want to sell Australian wine. And why would that be a problem? Why would that seem to eliminate the mutuality of the deal that they made? They agreed on the price, they agreed on the time. But what's the problem if he can say, I'm not satisfied, I wanted an Argentine wine shop, and they offered me an Australian wine shop?
Because there wasn't enough reason to.
Yeah, it seems to give him too much discretion just to decide. Maybe he has some other reason to back out of the deal. Like this lady, she had some other reason, like she probably decided she wanted more money. He could have come up with some other reason and said, I want to back out of the deal because I've decided to get out of the real estate business and I'm going to move to Monte Carlo, whatever. But it seems to give him an unlimited power to just back out of the deal. And that sounds reasonable, right? That's not mutual. He can back out, but she can't back out, of course. So maybe you should decide the case the other way, but it wasn't decided that way because he's not the one who backed out. But what is the reason that the court gives for saying it's okay that he had this clause that allowed him to back out of the deal if he wanted to? One, it's important that he did not do that. Don't lose sight of that. It's important that that did not happen. But just in the theory, sometimes the court is discussing the theory more than the reality. What's the theory that the court comes up with that that's okay and there's still an enforceable contract here? You know, what do you need for consideration? You need consideration can come from giving something to somebody. Does this clause about the satisfaction with the leases, does that give anything to the seller? Does that give anything to the lady selling the land?
The money.
Well, he gave her money. Yeah. Well, see that, and that's another issue that the court doesn't talk about that, but he had given her some money and he had promised her some money. And was he trying to back out of paying her? What did he do when she said, I'm not going to sell?
Go to the court.
Well, first he went to her and he said, okay, I'm prepared to pay all the money and I am satisfied with the leases. So when she said, I'm going to back out, first thing he does is go and say, I'm willing to do everything I promised to do. I'm willing to finish this deal. I'm willing to pay you the money. I'm not complaining about the leases. So that's one issue. He's not the one trying to get out of the contract, but you're correct that's probably in the court's mind that he has $1,000. And is she going to get to back out and say, and this raises another concept, important law contract, which is, and we'll look at some cases about this, is called unjust enrichment. That's a American English law legal term. And without my explaining exactly what that means legally, how do you think that applies to this case if she backs out of the deal? Unjust enrichment. How is the lady unjustly enriched? Well, she's backing out of the deal and keeping the $1,000.
Yes.
Yeah. So has she been enriched? Yeah, she's got $1,000. Is it just? What did she get? What did she do for the $1,000?
Nothing.
Nothing, less than nothing. She actually screwed this developer up. He had plans for a condo in Irpin, and she's messed up his deal. And so why does she get to keep the $1,000? Is the court, the court doesn't say that, but that's another concept of unjust enrichment. She got $1,000 of his money and did not do anything for him. It's got a reverse consideration. She got, what was the consideration she gave for the $1,000? Nothing, except, to, make this poor real estate developer's life miserable. Sometimes that's the consideration you get from people. They make you miserable, ruin your life. Say, I'll take $1,000 to ruin your life. Thank you. You probably know some people like that. So anyway, another concept this case introduces, and we'll look at more specifically later, unjust enrichment. But anyway, we're back to consideration. So and forget about this, he's given her $1,000, but just think about this clause that gives him a chance to be satisfied with the leases. What is the lady's consideration for that? Now, you could argue that the $1,000 was the consideration to give him that ability. Say, I have the ability to decide to back out of the deal, but I've given you $1,000 to have that right. You could argue that, couldn't you? I would, if I were the lawyer in the case. I would say $1,000 was consideration for my ability to back out if I was not satisfied with the leases. Deal didn't go through, but she's got $1,000. But if you forget about the $1,000, just looking at that lease provision, the provision that gives him 120 days to decide if he's satisfied with the leases, and say he hasn't given her any money for that. So what's another way that it could be consideration? What does the court say? Why does the court say it's consideration? Where is the consideration? The court doesn't talk about what I talked about contract formation. It doesn't talk about unjust enrichment. These are alternative theories that if you were the lawyer, you could have argued. If I represented the developer, I would have said unjust enrichment. She kept $1,000 for nothing. Or I could say, actually, the $1,000 was a consideration for my right to agree to back out if I didn't like the leases. But what does the court say is the consideration? I might have read it and said, I don't understand this. And you might have thought, maybe it's because my English is not good enough. In reality, it doesn't make that much sense to me out of all the different things. And it makes you wonder, like, what are they teaching these American students in these contract law courses over there? Because our professor tells us all these cases are wrongly decided and the judge looked at the wrong thing and considered the wrong issue. But the judge in the case says, or it might have been an appeals court panel of judges, said that the consideration for the clause that allowed the developer to back out if he wasn't satisfied with the leases came not because he paid her money for it, but because another form of consideration is a duty or an obligation. So if you incur a duty or you give something up, consideration can be giving something up or taking on an obligation or a duty. Either one can be consideration. What is the obligation that court says that the real estate developer has taken on? It might be hard for you to understand because it's not necessarily what makes the best sense. In fact, it kind of reminds me of the case where, the court can't come up with any real consideration. So they say the piece of paper the promise was on, that was the consideration. And in this case, they say that when the developer put in this clause to say he could back out if he was not satisfied with the leases, what was the duty he took on? He took on a duty of good faith that attaches to the contract, because the court says, and it's kind of counterintuitive, it sounds like he can back out on a whim, just an arbitrary reason. Like, I wanted a French restaurant, I got an Italian restaurant, I'm backing out of this deal. But the court says, actually, in a satisfaction clause like that, there is a legal duty to conduct it in good faith. That you can't just say, I want to, back out because I, decided that the price was too high. I'm paying this lady too much. So I'm going to use this as a pretext to back out of the deal. I really think the price is too high. And I'm going to say, well, I don't like the lease. I wanted a French restaurant, got an Italian restaurant. The court says for a satisfaction clause like that, you cannot do that. That you have to exercise that duty in good, you have to exercise that option in good faith. And therefore you are incurring a duty that serves as consideration. Again, it's probably the right result in the case in a kind of backwards roundabout way that y'all obviously did not understand, that the court comes around to find that there was consideration for that clause, and that was the duty that the real estate developer incurred to, exercise his discretion in good faith. He could not arbitrarily just say, yeah, I'm not satisfied with the leases. Now, what would happen in the case? Different case, right? If Coldwell Banker, the real estate company, comes back to the developer and says, sorry, developer, we couldn't get you any leases. We couldn't get a nail salon in there. We couldn't find a wine shop that wanted to be, downstairs in your development. We couldn't find a French restaurant. We couldn't find an Italian restaurant. We couldn't find an Ethiopian restaurant. Couldn't find any restaurant. How would that affect this case if the developer who wants to build this condo building and put, some tenants downstairs, these businesses paying him rent? And what if the real estate company comes back and says, we couldn't find you a single tenant. have nobody to rent your building. What happens then?
He wasn't satisfied.
Well, he wouldn't be satisfied. And if he had tried to back out, would the court allow that?
Yes.
Probably so. Is that really fair to that lady selling the land? It's not really her problem to get him tenants, is it? That's his problem. So I don't know. This is one of these, that's not the case that happened, but it's an interesting thing to think about. It might be an exam question for your course. It's like, what? You know, you're the judge. No tenants, can't find a tenant. What's the outcome of this case? Could he back out? Could the lady make him pay her the $57,000? Said, you agreed, we signed a deposit agreement, gave me $1,000, promised in good faith, da, da, da. So anyway, but, and the thing I noticed in reading the people who turned in case briefs with the key facts, when I say key facts, like really focus on the key facts. And again, think like you're talking to the judge, and the shorter the answer you can give the judge, the better. Of course, that the shortest answer you can give, that gives the judge the information he needs. So remember what I said at the beginning, if the judge opens the court, says, counselor, what's this case about? And you say, it's whether the promise was illusory. I'm the judge. I'm like, what does that mean? How can I decide the case? What promise? Why is somebody claiming it's illusory? So when you're talking about the issue, you got to include that stuff, not just is the promise illusory, but is this, contract illusory when the developer has the right to back out if he's not satisfied with the leases? That's really the issue, right? That's the complete issue with the facts built into it. That's what the judge needs to hear. I always think, what does the judge need to hear to decide my case? Okay. Oh, okay. Let's talk about, we got a few minutes left. Let's talk about this. Well, let me see if there's anything I forgot to cover. Oh, another thing I meant to bring up about this Mattei versus Hopper case. You need to look very carefully, and especially when talking about this crazy English American common law system built on this case precedent, is what we call distinguishing the cases. So remember, there are some cases the court talks about where which were raised by the lady's lawyer. She said, look, here are some examples where the contract was not enforced. Because that's what the lady wants, right? She doesn't want the contract to be enforced. She wants to say, there was no contract. I just made an offer and he never accepted. And so, I'm not bound to go through with this deal. So her lawyer offered some cases, which the court discusses, where the court did not enforce the agreement. And look at those cases. In every case, the court says, yeah, that's a case where they did not enforce the agreement, but the facts were different. There was a different fact that created a different outcome. That's called distinguishing the cases. That, yeah, you have a case where the court said, no contract, lady doesn't have to sell the land, but there was something different about that case. And that's the best thing you can learn to do as an attorney, and at least in the American English system, is learn to distinguish between the facts of the cases. So when you're talking about the facts of the cases, and some of them were kind of long summaries of the case. That's really not what you want. We'll try this exercise again, because I think it's important for y'all to get this down. I think it will help you to learn this and to use this tool for analysis. But when you're talking about the facts of the case, if I'm the judge and ask you for the facts of the case, it might be necessary in a really complicated case, but I really do not want to hear a 2-page, what are the key facts of the case? And then, here, judge, let me give you 2 pages worth of summary and stuff. I want you to narrow it down, hone it down to like the really key things. The shorter you can tell me and not leave out anything important, the better. You don't want a long answer for the judge. You want the shortest answer that includes everything that you want the judge to consider, and then cut out the rest. So the judge said, what are the key facts in this case? Bam, bam, bam. And I would say one thing, if I were representing the developer, I'm like, what's all this about whether we could back out of the deal? We're not trying to back out of the deal. It's that lady's trying to back out of the deal. So, and we were satisfied with the leases. So what's the problem? And I'm not sure I would have argued, well, we had a good faith duty to not arbitrarily back out of the contract, even though we had a right to. That would not have been the argument that sprang to my mind. But distinguishing the facts of the cases. So, and it's important to understand conceptually that the court decided there was a contract. This was not just offer and acceptance. This was not in the process of formation. That this lease approval condition did not mean that there was not a contract in existence. And again, it's partly because what are the most important things? The price. Had they agreed on the price? Yes. Had they agreed on the time? Yes. So the most important things were agreed to, but I think it's also in the end critical that she's the one who tried to back out of it. I think of, is this a different case if it's the real estate developer trying to back out of the contract by saying, I'm not satisfied with the leases? Different case, probably. Okay. Got a few minutes left to talk about Weiner, which is okay, because we talked a lot about employment law last time. We talked about this concept of at-will employment. So somebody tell me, what is the issue in Weiner versus McGraw-Hill? McGraw-Hill is a publishing company, published books. And Weiner goes to work for them. And why does this end up in a lawsuit? What happened?
Weiner claimed the defendant broke a promise because when he was they discussed about employment and the defendant McGraw-Hill Incorporation.
Okay, well, let me stop you there, Tatiana, because you're on the right track to the right answer. But also think of the lawyer of the dramatic effect. You're arguing your case. What is the number one reason we're in a lawsuit? Is because they fired him, right? They fired Weiner. So that's the first thing. They fired him. And then after and why is Weiner saying they couldn't fire him?
Because they promised that they fire him.
Where did they promise?
because-
Where's this promise? Is it in a written contract? Is there a 20-page contract when he was hired where they had a lawyer write out all the terms of his employment? Yeah, I think it's important to understand the basic facts of this case, which might be hard for y'all to get. So Weiner, he's relying on the employee handbook, right? And the employee handbook says to fire somebody from McGraw-Hill, this is what you have to do to fire them. And it says you have to, have to notify them of what they're doing wrong and give them a chance to improve their work or whatever your complaint is about. And that you have to fire, you can only be fired for good cause. So what does that mean compared to what we talked about last week, where the default, the understanding in the United States, unless you have a contract that says something different, that you are an at-will employee. What does that mean to be an at-will employee?
It means that they can fire him when they want.
For any reason, as the saying is, they can fire you for a good reason, a bad reason, or no reason at all, including the reason can be a lie. A lot of people go try to fight their employment, say, they fired me because they said I was late to work every day. I was never late to work. And actually, that's true. The employee was never late to work. The reason they gave was false. The employee goes to court. He proves I was on time every day. And they fired me saying I was late every day. And the judge dismisses his case. Why? He proved they were lying.
Because he worked at will.
Yeah, because the court said, it doesn't matter if they were lying. They can fire you even if they're lying. They don't have to have a reason. They can have a bad reason. The reason can be a lie. You're an at-will employee. They can fire you anytime they want to. They don't have to give you a reason. So if the reason is a lie, that doesn't matter. And that's the case if we talked about, cases being dismissed as a matter of law, that a court can dismiss a case without a trial. And we've seen that in some of these cases where the judge just said, I'm not even letting this go to trial. I'm dismissing your case right now because as a matter of law, you don't have a case. Even if everything you say is true, you don't have a case. And that's true in the case of an at-will employee who comes in and says, the reason they gave for firing me was a lie. The court says, it doesn't matter. Even if that's true, you lose. Your case is dismissed. And that's the only circumstance in which a court is supposed to dismiss a case without allowing a trial, without allowing people to present their evidence and a jury to hear and decide, or sometimes the judge decide. But even if everything you say is true, you still legally don't have a case. So what would you say the issue is in this case? Well, what's the position of McGraw-Hill? They fire Weiner. Weiner sues them. They say he doesn't have a case. Why? They're saying he's an at-will employee, right? They can fire him. And that's, even though the handbook says, the McGraw-Hill handbook said, you can only be fired for a good cause. What that means is that they really have to have a real reason. Good cause means they have to have a reason. They can't fire him for no reason at all. So their handbook says he can only be fired for a good cause. If that's true, that means he's not an at-will employee. Why does McGraw-Hill say, well, it doesn't matter what's in our handbook? And this is a common thing. This comes up in employment contract disputes all the time about the company handbook. And what the companies try to argue is, well, that's our handbook, but it says this in the handbook, but that's not a contract. That's not an enforceable contract against us. And does anybody remember why McGraw-Hill says our handbook's not a contract? Why not? These are the things you need when you read the cases. You're getting an idea of like what are the facts, important facts you should be digging out of these cases. McGraw-Hill says it's our handbook and we write it. We didn't bargain with Weiner for the handbook. We didn't sit down and have a negotiation with him and say, this is what our handbook will be, and you agree on these clauses. We write the handbook. Weiner had nothing to do with it. And we can change our handbook anytime we want to. Therefore, it's not an enforceable contract. There's no, remember from the other case, there's no mutuality. There was no negotiation, no bargaining with Weiner over the terms of this contract. Why does Weiner say that, yes, you're bound by that handbook, what it says? What did they actually sign? Did they sign the, so we've already said they never sat down and signed a 10-page employment contract.
No, they signed a form.
Yeah, when he was first hired, signed a form as part of the interview process or something. How many of y'all have already gone and interviewed for a job with a company? When Weiner is interviewing for the job, he signs some form that says that, and that form, and remember, this is like the case before us. The real estate developer, they didn't have a 10-page contract either. They just had a form that the real estate company used. They used the same form for everybody. It's not a negotiated contract. It's a form they give to everybody they're going to buy some property from. Here, this is a form that McGraw-Hill gave everybody that they were interviewing for a job. Here, sign this form. But why did Weiner, what was his position on why the form meant he was not an at-will employee and that they could not fire him just for any old reason or not give him a reason? What did the form say?
Because on several occasions.
Well, before that, I know you're going, and that's correct, but there's something before that. The form says that if he gets a job there, the terms of his employment will be what's in the handbook, right? The form says that your employment is guided by our handbook. So that's why he's saying, I signed a contract with you that you have to follow that handbook. Now, and then there's another reason that you're about to say. What's the second reason, Tatiana? That he says that handbook's enforceable.
He alleged that on several occasions he had recommended that certain of his subordinates be dismissed. He was instructed by supervisor to proceed in strict compliance with
the short answer is when he wanted to fire somebody, they told him, you have to follow the handbook. You can't fire anybody without following the handbook. And now that they fire him, they say, we don't have to follow the handbook. He said, well, so that's an important concept. It's not only in contract law, but international law, like course of dealing, like what in international law is called custom, like what people have done before, the practice they followed becomes enforceable. That's the way we do things. So when Weiner wanted to fire somebody, they said, you have to follow the handbook. And then they fire him and say, well, we don't have to follow the handbook. Well, that was not the course of dealing. That was not the custom. So he had the signed form when he was hired, that he'd be hired subject to their employee handbook. Then he had their course of dealing, like that's what they always did. But now they want to say they don't have to do that. And then, of course, the third thing he says, which again, this shows how a lot of these cases have a lot of interrelated concepts. And this one brings up a concept we've seen in another case and talked about, which is reliance, that he had relied on what they told him. And remember, we talked about that was called promissory estoppel. And promissory estoppel means somebody's made a promise and it was reasonable for you to rely on that promise. You did rely on the promise, and then it's, unjust for the promise not to be enforced. How did Weiner rely on the promise in the handbook?
He rejected all his fringe benefits and also he rejected other offers.
Yeah, so that's great. That's perfect, Tatiana. He relied on what they promised him. So now they're going to say, we're not bound by that promise. And why are they saying it's just our handbook? We wrote it, we can change it. But it's a different story because Weiner is saying he relied on that promise. So think about the basic concept. I say, Tatiana, I promised to give you $1,000. Can you make me give you $1,000 now? I promise to give you $1,000.
No.
No. First, there's no consideration. So there's no contract. But what if I say, Tatiana, I'll give you $1,000 if you go stand out in the rain all day. And you go and do it. What's different?
It was a consideration.
Well, not exactly. And think of it, it's a different concept. So consideration makes it a contract. Promissory estoppel is when a promise is enforced even though there's not a contract. So it's enforced because you relied on my promise. If I make you the promise, give you $1,000, and I don't keep my promise, I'm a bad person. I don't tell the truth. I didn't keep my promises, but you can't do anything about it. You can't take me to court and say, you promised to give me $1,000, professor, fork it over, give me the $1,000. You can't do it. The court will say, sorry, no consideration for the promise. But what if you rely on my promise? There's still no contract, but under this other concept of promissory estoppel, the court said, we're going to enforce that promise anyway. It's not really a contract, but it's unjust for Tatiana to rely on that promise and then be stiffed. And then it's a next step we talked about, unjust enrichment. What if I benefit? What if I benefit somehow? Then this unjust enrichment. I didn't keep my promise and it cost Tatiana something and it benefited me, like in the case of the real estate developer who gave the $1,000. The lady going to keep the $1,000 and not go through with the deal. She's unjustly enriched. So these are, usually these cases, the judge will say, this is about one thing. In the developer case, they say, we're deciding this because we're saying there was consideration, because there was a duty of good faith, to, you know, to exercise the condition about approval of the leases in good faith. But really, there are a lot of other concepts mixed in going on at the same time about unjust enrichment, about reliance. You know, that developer, he could say, I relied on her promise to sell me that property. I went out and did all this work. I got leases. I went to Coldwell Baker and worked with them and get the leases. I went to an architect, paid him for the plans for the condo. I relied on her promise. So all these things are mixed up. We're over our time today. I'll send you some other fascinating cases to read for next week. And we'll try one more time to get everybody to write a case brief, because it'll be good for you. It's like medicine. It might not taste good, but it's good for you. And y'all have a happy Easter. And I will see y'all next Wednesday.
Thank you. Goodbye.
Thank you. Bye.
Thank you.
Thanks.
Goodbye.
Have a nice day. Goodbye.
Nice day.